I'm Dr. Karin Huffer, and we are continuing our Unlocking Justice series. Today I have with me Don Ellen Mo Frederick. I'm going to be calling him Mo because that's what I know him as. Attorney, certified ADA advocate, Americans with Disabilities Act advocate, and a facilitator at Phoenix University where he teaches students of various kinds, but mostly in business law.
Business law, criminal justice.
Business law, criminal justice at University of Phoenix. We're going to be talking about the questions I have been asked because, as you know, this series has to do with answering the many, many questions that came in after this book, Unlocking Justice, was published. And we're going to be talking about people who are not feeling served by the courts being overwhelmed, why some of our clients cannot seem to get and keep attorneys, and what is happening that we can help by better identifying the invisible disabilities and stressors in the people who are using the court system to better serve the economy of the court and the public. So welcome, Mo.
Thank you. How are you doing?
So you heard what I'm talking about. I'm saying that I was motivated to write this book a lot because I believed that people were locked out of justice. No fault of their own, no fault particularly of the system, but a way that has evolved that is not serving the public well in many cases. Are you seeing the same thing?
I absolutely am. I would say it's so systematic that there needs to be a change. There needs to be, I think you taught me in my training, there needs to be a revolution of some sort starting from the grassroots of education and in the professional system. For example, I'm really sure we have no classes in law school about how to deal with persons with disabilities, visible disabilities or invisible disabilities. So the system is pumping out many attorneys who have no idea how to recognize a person that may have special needs and may need special accommodation and may need special attention, because we're pretty much trained to just be litigators and perhaps aggressive litigators, and certainly there is just no sympathy for this particular arena right now. So I would imagine that when we're being taught to be aggressive, we're being taught to be ignorant, maybe, then we're not serving everybody as well as we should be.
I'm noticing the same thing. When the questions come in and the problems come to me through email, etc., people are complaining that they get into the court and many times simply can't function. Then opposing counsel actually uses that to exploit that weakness. So it was my thinking, if we could identify what those weaknesses are. If it's a matter of just stress going to court, everybody knows you have that. But if the person actually has depression, anxiety, bipolar disorder, post-traumatic stress disorder, traumatic brain injury, and it's not identified and it's not accommodated, and they go into the court and then they're subjected to the adversarial, zealous representation where the attorneys get, I witness it, cruel. They will say very terrible things, the character assassination, anything to go ahead and further weaken the person. Again, not knowing that they have a diagnosis. Then when they interpret what's going on to the judge, what I find is they put to the judge the person is crazy, unfit to parent or to handle their affairs, non-compliant, not cooperative. So then the judge notices the symptoms, misinterprets them, and then begins punitive action against the person, furthering the condition. That's what I am calling legal abuse syndrome, when virtually they begin to have symptoms of post-traumatic stress disorder based on just that experience alone.
Absolutely. I think it goes a little further back than that. I'm often concerned about the guardian ad litems, the child legal representatives, the parental responsibility evaluators. Those are some of the paraprofessionals that we have here in Colorado that do these evaluations of people, and perhaps in one sitting they realize they see a person that is inattentive, is drifting, is just not there. And in all fairness, if you don't have training, you may not recognize that that person really just has a disability, doesn't function well in front of professionals, that doesn't function well in front of people that they have a natural fear of. What can this person who my life is in their hands do to me, really is how they feel. And if this person just doesn't even seem to be a part of the conversation, it's almost a natural assumption that, wow, that must be the way they are around their children, and they must be inattentive, and they must be, in the longest stretch, unfit, and so they're treated that way. And these reports are given to the judges, and judges rely heavily on these reports. That's why, one reason why we try to avoid litigation is to have some neutral person come and do all of the investigating, perhaps for a cheaper price, so that we don't have to have so much arguments in the courtroom. And so when they read these reports that they rely heavily on, they're just going to naturally assume that a professional has told them this parent or this parent is this or this. And that can be unfair to the person, to the parent, that otherwise is not being recognized as having a disability that can be an excellent parent.